My client is being questioned in a medical malpractice case in a pretrial question and answer session known as a deposition. She is asked to describe a conversation that she had with someone in the hospital. And as soon as she starts talking about that conversation, one of the first things I want to yell out is, "Objection! That's hearsay!" Can I do that during the course of questioning in this pretrial deposition? You want to know the answer? Come join me as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Okay, so here's the scenario. You brought a lawsuit against your doctor claiming that he was careless and that his carelessness was a cause of your injury. And now during the course of your lawsuit, your doctor denies all of your allegations. So what happens then? What happens then is that at some point during the course of your lawsuit, you will have to give testimony. You will have to answer questions by the attorneys who represent the various doctors whom you have sued. That's known as a deposition. Lawyers also call that an examination before trial. Now, this takes place in your attorney's office, in his conference room. There's no judge there. There's no jury there, but there is a court stenographer there to record all of the questions you are being asked and all of the answers that you give. So now there may be one defense attorney, there may be two, there may be multiple defense lawyers who represent the different people or hospitals that you have sued. Now, during this questioning, there will be many instances where the opposing attorney will go ahead and say, "Okay, Mrs. Jones, what did you and this other person talk about when the doctor came into the room?" And now you'll have to relay and try and explain the conversation that you overheard or participated in. Now, you should know, if this were taking place at trial, any time a witness goes ahead and is asked to talk about a conversation that he had with somebody else, now that's known as hearsay. When you go ahead and explain that conversation, guess what? The opposing lawyer doesn't know and has no real way of knowing whether or not the information you're talking about during this conversation is true or not. That's the problem with having somebody talk about a conversation. You don't really know whether or not the events that took place really are true. How can you avoid that? You can avoid that by bringing in the other person to the conversation. Okay, so let's say it was a nurse. In that instance, maybe the nurse is no longer employed by the hospital. And now, can you go ahead and talk about the conversation? The answer is, during the course of a deposition in your attorney's office, yes, you are allowed to go ahead and talk about those conversations that you had with other people. The attorneys for themselves will have to decide, okay, should we go ahead and try and question that nurse? Should we go ahead and try and question that doctor who's not part of this lawsuit in order to determine whether or not the substance of this conversation actually took place and is accurate and true? If the answer is yes, then now we can go ahead and have another pretrial deposition, but at this time it's called a non-party deposition, where attorneys go ahead and now will ask that particular witness questions about the various conversations that he or she had with the person who is party to this lawsuit. So why do I share this quick information with you? I share it with you because it gives you a clear sense of what really happens once you bring a lawsuit and now you're asked to give pretrial testimony, and now you're asked to talk about a conversation that you had with someone who's not a named party to the lawsuit, and now typically that is usually hearsay. But during the deposition, we are allowed to ask questions about it. The witness is permitted to go ahead and talk about that conversation and talk about what they remember happening during that conversation or what they overheard somebody else say. That's very important. Whether or not we could use that particular information at trial is a whole different issue of evidence. But if questions about your matter and are thinking about bringing a case, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.